Let's begin. So this is the fifth and final installment on a set of lectures I've been giving about the civil rights movement and its accomplishments. And this final lecture is about the movement and freedom of expression. 1965 witnessed the publication of a set of lectures that served in substantial part as the model for the lectures I've tried to offer these past few weeks. The author of that set of lectures was Harry Calvin, Jr., a distinguished professor at the University of Chicago Law School. And the title of his lecture series was The Negro and the First Amendment, an effort that traced connections between civil rights and civil liberties, or more specifically, the judicial consequences that attended the struggle of the Negro movement to ward off efforts to silence it. Calvin compliments highly the movement and the federal courts, most especially the United States Supreme Court. As he put it, the story is a happy and encouraging one. The extraordinary tact and sure instinct of the Negro protest has made it primarily a massive petition for the redress of grievances. And a gallant and sensitive United States Supreme Court has responded with an appropriate and exciting reworking of First Amendment doctrine. There was reason for this upbeat appraisal, especially given the time at which Calvin penned it. By 1964, federal courts, most notably the Supreme Court, had helped repeatedly to protect various civil rights organizations, but most particularly the NAACP, against attacks unleashed by segregationist states. In 1956, the Attorney General of Alabama sued the state affiliate of the NAACP, charging that it had failed to file a required corporate charter with the Alabama Secretary of State. Seizing upon this error, the Attorney General of the state tried to destroy the organization, demanding, among other things, the names and addresses of all members of the Alabama NAACP. When the NAACP refused to comply, fearing the repercussions that would befall exposed members, a state judge held the organization in civil contempt and fined it $100,000. Although the state Supreme Court affirmed this ruling, the federal Supreme Court reversed it, maintaining that the state had failed to show sufficiently a real need for the names, especially in light of the chilling effect this would have on the willingness of people to join organizations like the NAACP, because the Supreme Court indicated its recognition of what would happen to those who were found out to be members of the NAACP. And it's so interesting nowadays. Membership in the NAACP is viewed as, really, frankly, no big deal. Anybody, lots of people are members of the NAACP. People are generally not afraid to indicate publicly that they are members of that organization. In the 1950s, to be a member of the NAACP in Alabama, to be a known member of the NAACP in Mississippi, to be a known member of the NAACP in, let's say, Arkansas, was a real big deal. It might cost you your job. It might cost you, in some places, your life. In 1958, at a special session, the Arkansas State Legislature required as a condition of employment for public school teachers to file an affidavit listing, without limitations, every organization to which the teacher had belonged or given money in the previous 5 years. The aim, of course, was to cripple the NAACP by exposing members to public censure and ostracism. Although the Supreme Court of Arkansas upheld the statute, the federal Supreme Court struck it down, saying that to compel a teacher to disclose his every associational tie is to impair that teacher's right of free association, a right closely allied to freedom of speech and a right which lies at the foundation of a free society. Let me give you a third instance of the Supreme Court protecting, showing solicitude for civil rights organizations in this period. The Commonwealth of Virginia enacted a statute forbidding the very practices that NAACP attorneys had used to obtain clients. This is in the period right after Brown versus Board of Education. Reversing lower courts, the Supreme Court ruled that the activities of the NAACP, its affiliates, and legal staff are modes of expression and association that warrant First Amendment protection. Previous to then, the activities of lawyers in getting clients had not been thought of as a First Amendment activity. But faced with suppression from the authorities in Virginia, the lawyers for the NAACP and others rethought it and said, well, can't litigation itself be a type of political expression? And the Supreme Court listened to them and agreed with the NAACP's attorneys. Elaborating on this point, the court remarked that for the NAACP, litigation is more than a technique of resolving private differences. Quote, "It is a means for achieving the lawful objectives of equality of treatment. It is thus a form of political expression. Groups which find themselves unable to achieve their objectives through the ballot," remember the lecture from yesterday, "frequently turn to the courts." Showing that it understood what Virginia was attempting to do, notwithstanding the packaging of its new statutes, the court observed, quote, "We cannot close our eyes to the fact that the militant Negro civil rights movement has engendered the intense resentment and opposition of the politically dominant white community of Virginia. In such circumstances, a statute broadly curtailing group activity leading to litigation may easily become a weapon of oppression, however even-handed its terms appear. Its mere existence could well freeze out of existence all such activity on behalf of the civil rights of Negro citizens." Oh, what the heck, I have to give another example. Let's go back to the place, one of the places I began with a couple weeks ago. Let's go back to Montgomery, Alabama. In Montgomery, Alabama, L.B. Sullivan, a city commissioner, filed a libel action in 1960 against a variety of defendants, including the New York Times. He charged that the Times wrongfully besmirched his reputation by publishing a full-page advertisement that disseminated some inaccurate information. A jury agreed, awarding Sullivan $500,000 in damages. An affirmance of this judgment would have inhibited journalists by making their newspapers and magazines vulnerable to hostile local juries that, empowered by libel law, could potentially bankrupt media companies. The Supreme Court, however, nullified the jury's verdict, dramatically narrowing the power of public officials to sue for libel. The court insisted that a state cannot award damages to a public official for defamatory falsehood relating to his official conduct unless he proves actual malice, that the statement in question was made with knowledge of its falsity or with reckless disregard of its accuracy. The court came to this conclusion and observed, against the background of a profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. One of the most quoted statements in the jurisprudence of Justice William Brennan. Or another example. Got to give this one because this one goes back to my people in Columbia, South Carolina. In Columbia, South Carolina, authorities arrested and convicted 187 protesters for breach of the peace. Their crime was refusing to disperse within 15 minutes of being directed to do so by the city's police chief. Assembled on the grounds of the State House, the protesters avoided impeding traffic or indulging in any threatening remarks, hostile gestures, or offensive language. They merely walked two abreast in an orderly fashion, carrying placards that read, "I am proud to be a Negro," and "Down with segregation." They also sang religious and patriotic songs while stamping their feet and clapping their hands. The Supreme Court reversed the convictions which had been upheld by the South Carolina Supreme Court. "It is clear to us," Justice Potter Stewart declared, "that in arresting, convicting, and punishing the petitioners under the circumstances disclosed by this record, South Carolina infringed the petitioners' constitutionally protected rights of free speech, free assembly, and freedom to petition for redress of their grievances." Justice Stewart's description of the petitioners' conduct was by no means neutral. It was laudatory. This case reflected, Stewart declared, an exercise of these basic constitutional rights in their most pristine and classic form. So there was, as these cases illustrate, a basis, a real basis, for Calvin's admiring portrayal of the federal court's rulings regarding the liberties of civil rights protesters and their organizations. There was a real basis for the sort of smiley face portrait that one finds in reading Harry Calvin's wonderful set of lectures, The Negro and the First Amendment. There is, however, a strong basis for believing that Calvin's conclusions were also unduly optimistic. And for the next few minutes, I want to turn to some features of the struggle over civil liberties in the age of the civil rights movement that give a more sobering portrait of the fight for civil liberties in the struggle for civil rights. First, to go back over some of the cases I just mentioned, it's absolutely true that the Supreme Court of the United States showed a lot of solicitude, in fact, special solicitude, for the NAACP when the NAACP became the target of segregationists in the aftermath of Brown versus Board of Education. I mean, it was in Mississippi, in Alabama, in Virginia, in other places. Public officials went on record saying they wanted to destroy the NAACP. And the Supreme Court came to the NAACP's aid. The NAACP in these years in particular was not an ordinary litigant. It's not an ordinary litigant. It's not the case. I mean, it's formally speaking, it's the case that everybody goes into the courts on the same level. But that's not true. When the Solicitor General's office submits a brief to the Supreme Court of the United States, that brief is read differently than briefs are read by, any old Tom, Dick, or Harry, or Jane. The Solicitor General's briefs gets a closer look. Doesn't mean the Supreme Court's going to necessarily respond or respond favorably, but the Solicitor General's brief's going to get a closer look, typically speaking, than other folks' briefs. And there are other organizations. When the Central Intelligence Agency submits a brief to courts, I would posit, I would bet, those briefs get a special look. In the late 1950s and throughout the 1960s, when the NAACP submitted a brief, it was viewed as a special litigant. And these cases show it. So, in the late 1950s and the early 1960s, when the Supreme Court of the United States was warding off state investigations of the NAACP, we might look and we might say, oh, that's easy. I mean, of course there's organizational privacy. In the late 1950s and early 1960s, this was not easy at all, because states and the federal government they were deeply engaged in investigating organizations and trying to reveal the membership of organizations, and being quite successful in doing it. What was the organization that was largely the target of the federal government and various states? The Communist Party of the United States. The Communist Party of the United States was listed in various instances. You had to admit your membership or reveal your membership in the Communist Party of the United States. There were all sorts of actions taken against the Communist Party of the United States. No union, and this, by the way, is still the case. You cannot be a union protected by the National Labor Relations Act and have in your leadership a member of the Communist Party of the United States. That is true right now. It's been true for a long time. And so one of the things that this segregationists thought of was, we know how we can investigate the NAACP. We will portray the NAACP as a subversive organization. And actually, from the segregationist point of view, it was. It was subversive of segregation. And so they sought to use the very tools that were being used against the Communist Party. And the Supreme Court said essentially, no, you can't do it. The segregationists did not stop there. So they said, okay, the Supreme Court has said we can't do it. Is there something else we can do? They said, yeah, there is something else we can do. Fine, we're not going to attack the NAACP frontally, saying that it represents a subversion to our white supremacist way of life. Okay, that won't work. Okay, we'll try a different attack. We will seek to investigate the NAACP, not because the NAACP is subversive of segregation. We will seek to investigate the NAACP on the grounds that the NAACP, we think, has been infiltrated by communists. So one of the leading cases, the Gibson case in Florida. State of Florida says we have information indicating that the communists have infiltrated the NAACP. We're not going to claim, we don't necessarily know. Maybe the NAACP is not aware of this infiltration, but we're aware of it. We've been given, confidential information. So, director of the NAACP, we're going to subpoena you. We want you to bring the list. Mind you, we're not investigating the NAACP. We don't have anything against the NAACP. We're after the communists. But to make sure that we get to the communists, we've got to know who's on the list of the NAACP. The director of the Florida NAACP comes, brings the list, but says, I've got the list. I've got the list. But I'm not going to give it to you. And the reason why I'm not going to give it to you is because we think that we think that this list is going to be publicized, and if the list is publicized, members of the NAACP in Florida will be in a lot of jeopardy. The Supreme Court of the United States, in a very close opinion, 5-4 opinion, ruled for the NAACP. Four justices dissented. And they said, listen, we've allowed this with respect to other organizations. We've allowed governments, the federal government, state governments, to investigate. There is a communist menace, an international communist conspiracy. So, in our view, the state of Florida is within its rights going after this menace. 5-4. I mentioned, now, the reason why I mention this is the law that I mentioned earlier, the law that granted organizational privacy to the NAACP, it was an advance. There was no doctrine of organizational privacy prior to the attack on the NAACP. These cases gave birth to that legal doctrine. Just like there was no legal doctrine portraying litigation as a form of First Amendment activity prior to these attacks on the NAACP. So it was in advance. But it was an advance with certain limits. One of the things that the court said when it, defended its position, finding in favor of the NAACP, one of the things the court said was, we don't have to worry about the NAACP. We don't have to worry about the NAACP. The NAACP has shown that it is with the government in the repudiation of communism. One of the things that the NAACP did early in the 1950s was pass a resolution saying that you could not be a communist and be a member of the NAACP. In fact, the NAACP ousted from its ranks communists, or people who it thought were communists, thinking that this day would come. There are now a number of biographies of the great Thurgood Marshall, my former boss. One of the biographies that came out about Thurgood Marshall was a biography by Juan Williams, and in his biography of Thurgood Marshall, Juan Williams talked about having gotten, he made a Freedom of Information Act request to get the Thurgood Marshall's FBI file. And in reading through this file, showed and discovered that periodically Thurgood Marshall and other officials of the NAACP and kindred organizations would talk with J. Edgar Hoover and others at the FBI about this issue of communism. And the fact of the matter is, the leadership of the NAACP went out of its way to oust ideologically questionable people from its ranks. Now, this is something, it seems to me, in looking back, that one has to grapple with this. One has to grapple with this. The Supreme Court of the United States was willing to protect the NAACP, at least in part, because the NAACP had been willing to take steps that alleviated any anxieties about where it stood ideologically with respect to, the communist issue. We'll come back to this, because the communist issue, I'm not finished with it. Not finished with it by a long shot. Let me turn, however, to a second area that seems to me, at the very least, complexifies Harry Calvin's portrayal of freedom of expression in the age of the Civil Rights Revolution. Now, remember what I said about this case from South Carolina, Justice Potter Stewart talking about the demonstration in Columbia, South Carolina, being a pristine example of the expression, of the exercise of First Amendment rights. If you take a look at the photographs of those who were arrested, they were in their Sunday best. They were in their Sunday best. I know these people. I know whole bunches of them. They filed out of a church in their Sunday best. Very careful. No loud talking. The loudest thing they did was to sing "My Country 'Tis of Thee," to sing the Star-Spangled Banner. to sing their religious songs. That's what they did. And one of the reasons that they did this was because they were pragmatic. They were pragmatic. They were young, but they were pragmatic. And they knew the importance of reputation. They knew that they might very well be arrested. All of them went to that protest with a telephone number in their pocket. If you were in South Carolina in the late 1950s and 1960s and you were going to participate in the civil rights demonstration, you made sure that you had the telephone number for a law firm in your pocket. And there was one law firm. It was the Jenkins Perry law firm. Matthew Perry later became the first black federal judge in South Carolina. In fact, if you go to the federal courthouse in Columbia, South Carolina now, it's the Matthew Perry courthouse. But if you were going to go on a demonstration, you had his telephone number in your pocket. In fact, and he argued the case. Edwards versus South Carolina. Now, that was late 50s, that was early 60s. Early 60s, you have these students, by and large, very well behaved. One of my favorite things from the 60s is a column that the segregationist writer James J. Kilpatrick wrote about a demonstration. He was writing about a demonstration that occurred, I forget where in the South it occurred, but he was writing about a demonstration. Now, James J. Kilpatrick was a thoroughgoing segregationist. But he writes this column and he says, I was looking on the news. And he said, I was looking on the news, it was on TV, and they were showing this sit-in demonstration. And he said, sitting in were these Negro students, coat and tie. They were sitting at the counter, doing their homework, reading books, polite as could be. And then he said there were white students behind them, jeering at them, throwing things at them. He said the white students were there in their T-shirts, ketchup spilled all over them, cussing, looking terrible. And James J. Kilpatrick said, I don't like what the Negro students are doing. I'm against them. But I've got to say, they seem so much more admirable than my folks. And it's giving me pause. It's giving me pause. Now, these demonstrators were really onto something. And one of the reasons why the Supreme Court of the United States showed extra solicitude, which they did in the late 50s and early 60s for the demonstrators, is because in their view, in the judicial mind, not only did they sympathize with the demonstrators, they admired them. They really did. Judges are human. The whole question of whether you even take a case at the Supreme Court is a discretionary issue. You don't have to. These demonstrators were really on to something in the way that they comported themselves. That was part of their armament. And this comes through in a case that was decided in the mid-1960s. In my view, a rather disturbing case. I'm sure that many of you have read this case. You probably read it in civil procedure. Maybe. Walker versus City of Birmingham. Who's read that case? Walker versus City of Birmingham. Only one? Interesting. Maybe it's been superseded. Here's what happened in Walker versus City of Birmingham. It's quite apropos. What's today? April 9th? April 9th? Okay? On the weekend of April 15th and 16th, 1963, that weekend, Martin Luther King Jr. and company were in Birmingham. It was the height of the struggle in Birmingham. Easter weekend was approaching, and the authorities in Birmingham went to a local judge, Judge Jenkins, and got an ex-parte order enjoining demonstrations, telling Martin Luther King and company, you cannot demonstrate. King and company, it had been well publicized, wanted to demonstrate, wanted to have a march on the symbolically important day, Good Friday. They wanted to march on Good Friday. The judge said, I'm issuing this order, don't march. Martin Luther King Jr. had to figure out whether he was going to listen to the judge's order or not. Now, on a couple of earlier occasions, at the advice of his lawyers, King, when faced with this, had backed down and not marched. Instead, his lawyers had sought to dissolve the injunction. This time, the timing, however, was he was right up against it. He was either going to march, or he was going to have to call off the march and go to court instead. King decided this time to march and defy the judge's injunction. He did march. He was arrested. It was from that arrest that arose the great letter from a Birmingham jail. That's why Martin Luther King Jr. was in jail. And it was in that context that he wrote Letter from a Birmingham Jail. Okay. He ultimately gets out, appeals his conviction for criminal contempt. Began this lecture series with a case involving criminal contempt. Mary Hamilton. Martin Luther King Jr. was in jail, criminal contempt. The case goes to the Supreme Court of the United States. Martin Luther King Jr.'s lawyers, Jack Greenberg argued this case. Martin Luther King's lawyers say to the Supreme Court, hey, this was a clearly unconstitutional ex parte injunction. Clearly unconstitutional. And so, King had a right to disregard it. It's clearly unconstitutional. The Supreme Court of the United States ruled against Martin Luther King Jr. Walker versus City of Birmingham, they ruled against him. And the Supreme Court of the United States said, hey, listen, what you should have done was seek to have gotten the injunction dissolved from a higher state court, and if that didn't work out, then from the federal courts. But you should not have taken it upon yourself to disobey a court order. If the judge had apparent jurisdiction, even if the order is legally wrong, you've got to obey it. Justice Potter Stewart wrote the opinion for the court, and he said this in the process of making his ruling. Respect for judicial process is a small price to pay for the civilizing hand of law, which alone can give abiding meaning to constitutional freedoms. Now, remember what I said, this case arose in 1963. The Supreme Court did not come down with its judgment until 1967. This is a speculation, obviously, but I speculate that if the Supreme Court of the United States had made a ruling in 1963, in 1964 or in 1965, it would have been just the other way. I think they would have ruled in favor of Martin Luther King Jr. and company. But it came down in 1967. Well, what had happened between 1963 and 1967? A bunch of things had happened. A bunch of things that happened in those years. By 1967, the United States had had 2 years of long, hot summers. There had been rioting throughout the United States. In 1963, in 1964, that was before Stokely Carmichael and others had voiced a demand for, among other things, black power. In 1963, 1964, 1965, there was no Black Panther Party. But by 1967, there was. And in his dissent, William O. Douglas sort of spilled the beans on this a little bit. William O. Douglas's position was, this is a clearly unconstitutional order that this local judge had issued. And the Supreme Court of the United States should not empower local judges to essentially freeze civil rights demonstrators. And this is what he said, William O. Douglas, dissenting. "We cannot permit fears of riots and civil disobedience generated by slogans like Black Power to divert our attention from what is at stake here, not violence or the right of the state to control its streets and sidewalks, but the insulation from attack of ex-party orders and legislation upon which they are based, even when patently impermissible prior restraints on the exercise of First Amendment rights, thus arming the state courts with the power to punish as a contempt what they otherwise could not punish at all." Now, Harry Calvin's set of lectures had already been published by this time. But all I'm saying is that with the unfolding of the Civil Rights Revolution in the mid to late 60s, with a more militant brand of protest, with people demanding freedom now, with demonstrators in the streets acting in ways which were considerably more defiant, the courts responded. The courts, too, became more anxious, more concerned. The courts, too, like public opinion, started to engage in started to show the signs of a certain sort of impatience with the Civil Rights Revolution, and engage in activity which I would refer to as a sort of judicial backlash activity. There's a third thing that makes this period a more complicated story than the one that one would get from reading Harry Calvin's, again, wonderful set of lectures. And this third thing is truly disturbing and should be with us too. It does not involve, by the way, the courts very much at all. It doesn't involve the courts very much at all. But what I have in mind is something that happened outside of the courts. This was very important. And what I have in mind is a type of repression that occurred didn't generate much litigation, but it did occur. And what I have in mind is the actions that were taken by the Federal Bureau of Investigation and local law enforcement authorities, sometimes in secret. But let me just stick with the FBI. Let me just stick with the FBI. J. Edgar Hoover's FBI. If one goes to Washington, D.C., you can, see the big J. Edgar Hoover building. J. Edgar Hoover was a quite baleful presence in the United States during this period, who played an important role in this area. In 1962, while much of the United States was applauding Martin Luther King Jr., J. Edgar Hoover was telling people that King is no good. The Federal Bureau of Investigation attempted, quite literally attempted to destroy Martin Luther King Jr. The Federal Bureau of Investigation, along with, by the way, along with the permission, the acquiescence of President John F. Kennedy, and afterwards, President Lyndon Johnson, the Federal Bureau of Investigation had wiretaps on Martin Luther King Jr. They followed him around. The Federal Bureau of Investigation succeeded in putting right into the Southern Christian Leadership Conference a person who was an agent of the FBI. The lead accountant for the Southern Christian Leadership Conference was a person who, week by week, reported to the FBI. He was a paid informant. The Federal Bureau of Investigation listened in on Martin Luther King Jr. Now, let's go back to the comment, on what basis? J. Edgar Hoover claimed that Martin Luther King Jr. was, at best, naive about some of his advisors, and said to the president, I think, Federal Bureau of Investigation thinks that there's some people who are communists or are communist sympathizers who are advisors to Martin Luther King Jr. And to keep tabs on them, we need to listen in on Martin Luther King Jr. And so they did. They listened in on Martin Luther King Jr., and they sought to use the information that they obtained against Martin Luther King Jr. On November 21st, 1964, one of the leading figures of the Federal Bureau of Investigation collected highly embarrassing tapes of Martin Luther King Jr. They were tapes that showed that Martin Luther King Jr. was engaged in affairs with women not Martin Luther King's wife. These were, derogatory derogatory information having to do with his personal life. Leading figure of this Federal Bureau of Investigation put these tapes together and sent them to Martin Luther King Jr., along with an anonymous note indicating that Martin Luther King Jr. should commit suicide before suffering public exposure. That was probably the most dramatic thing that the Federal Bureau of Investigation did, but it didn't just stop there, and it didn't just stop with Martin Luther King Jr. The Federal Bureau of Investigation had, in fact, a program. COINTELPRO was its it was known as counterintelligence. The Federal Bureau of Investigation used its counterintelligence program against various organizations: the Communist Party of the United States, the Socialist Workers' Party, the Ku Klux Klan, and civil rights organizations. It probably reached the acme of its activities in an effort to attack the Black Panther Party. The Black Panther Party was thoroughly infiltrated by the Federal Bureau of Investigation. Some of the leading figures in the Black Panther Party were actually double agents of the FBI. And the FBI used its power to do all sorts of things. It used its power to put in positions of authority provocateurs who would say things and do things which put the Black Panther Party in a bad light. The Federal Bureau of Investigation tried to generate hostility between the Black Panther Party and other parties. The Federal Bureau of Investigation, working with local police, engaged in what can only be called assassinations. The clearest one being the assassination of the leader of the Illinois branch of the Black Panther Party. That assassination, by the way, led to litigation, years of litigation, and it was actually through that litigation that the FBI and local law enforcement, their actions became part of a record. And we know about this. This is not the fevered imagination of some law professor. There's actually considerable scholarship on this, and if you don't believe the scholarship, turn to the Church Committee report. Congress finally, belatedly, took testimony on this, and this is well established. So in thinking about the question of civil liberties in the age of the Civil Rights Revolution, one has to, it seems to me, appreciate the positive accomplishments. There was an efflorescence of libertarian constitutional doctrine generated by the struggles that we've been talking about over the past few weeks. That's true. And day to day, we rely upon that. Every time you go to a demonstration, you are in a way relying upon the work of Reverend Fred Shuttlesworth, Reverend Martin Luther King Jr. They were repressed, and the court stepped in and helped to create doctrine on which we really just almost unconsciously rely. And that was a good thing. But I think it's also important to recognize that there was repression that occurred during this period, which was never subject to litigation. And it's a type of repression about which we must be concerned to this very day. So when we turn back and take a look at the movement and freedom of expression, there is a lot about which to be happy and proud and appreciate. There is some part of the story, however, that it seems to me warrants our concern and warrants our continued attention. We've got a few minutes, is that true? We've got a few minutes for comments, questions, by all means objections. But before that, one last thing. I just want to say how much I have thoroughly enjoyed being with you. One of the things that happens when you're invited to give a set of lectures is if you're going to give them, if you're going to stand and deliver, you really have to sort of think about it. And that, as it turns out, because there are 1,000 things it is, it's very easy to figure out reasons to avoid actually trying to figure out what you think about something. But this occasion has prompted me to have to rethink things that I've written in the past. It's prompted me to have to do some, new research. And these lectures have gotten me a considerable way down the road to a book that'll be coming out sometime in the next 2 years. And for that, I am just deeply, deeply grateful. So thank you very much.